Signature Real Estate Group, welcome to your Tuesday sales meeting. We've got a ton of food. It is our last meeting of the year live, by the way. So what is happening?
What's going on? Your phone's
Okay.
How do you do that?
It is our last meeting in this office for the year. It is. This is it.
Forever.
Yeah.
Forever.
This is it. This is it. Say your goodbyes. Tell the office that yeah. So from here, next year, we will start at the Spanish Ridge office, which I think is the official name for it now. Yes? Janet loves the idea, so we're going to go with it. Spanish Ridge is going to be our new office space for our meetings beginning the first week of January. So be there or be square type of situation. Let's see. We are going to be doing a legal update. We've got a really cool meeting with, you can see our attorney behind me.
He's so happy to be here.
He's excited. We talked this morning about all the stuff that has been ailing him throughout the year of stuff that we do as licensees and the things that he hopes that we don't do in the coming year. So we'll talk a little bit about that. This should be a pretty good meeting. In the meantime, Janet, you've got any events that you want to talk about?
Lois has a CE class.
Okay, are you going to, Lois, come on over. Talk about it. Tell me. Tell everybody.
So tomorrow,
Hold for the mic.
1 to 4, is Law of the Land in this classroom here. It's a law, 3 hours, and if anybody wants to sign up, just see me over here and I'll put you on the list. And then if you want to sign up for any other classes, they're on the website, and go ahead and sign up for those. I've got 4 next month, and let's start getting some of these CEs cranked out so you can get them done.
Because now you have to do more CEs than you ever did before, right?
You do 36 hours.
So
So,
go ahead and get those out of the
Take
way.
at least 1 a month if possible, and then you can keep up on it. Okay.
And we have 4 coming up next month.
Yeah,
4.
4
of them. So you've got contracts, general, ethics,
an agency.
and agency. You can
I
get,
also have an hour probate class.
okay, and there's an hour probate class too, that's a 1 hour CE. So you can get lucky number 13 hours worth of CE classes done in the month of January. 13 hours of CE, yes sir?
Green Valley Christmas party. Thursday.
Green Valley has a Christmas party on Thursday.
White elephant.
It is a white elephant gift Christmas party. Sorry?
Ugly sweater.
Ugly sweater as well. Okay.
Christmas tree auction.
Christmas tree auction. Can you just get your ass
Pizza
over?
wings, beer, and
Pizza wings, beer and wine.
RSVP to purchase.
RSVP to Persia. So you do that through the app, guys. Use the app. Everyone is welcome, whether you're in Green Valley or not. Go ahead and RSVP to Persia. We had a great time at the Summerlin one. It was a lot of fun. Huh?
Was it fun?
Yeah, it was great. We fought over the same booze. Poor Beta kept getting his alcohol stolen.
Just like last time.
Just like last time. Yeah, alcohol seems to be a favorite for Signature. There's alcohol allowed at yours, right?
Absolutely.
Yeah, yeah. No, alcohol's allowed for gift exchanges. Bring it, bring it. That seems to be the best ones that get traded. There is that. So the open house class that I had scheduled for last week, I'm going to be redoing it. No offense, we're not doing it at Green Valley again. We're going to do it in the the Spanish Ridge office, and that will be. So that is going to, by the way, kick off the open house challenge for the year. It's the first time I'm finally doing it in January, so that you have an entire year to do 100 open houses. So that will kick off the challenge. In order to go and be a part of the challenge, you have to be at the class. Okay? Cool? And you get CE classes, and CE credits, by the way, 3. General. All right. Sorry? Janet, what's the date on that? I sent it to everybody. I can't remember. I think it's going to be right after. I think I did it right after our sales meeting. So when our sales meeting is done, 9:30, 10:30, we start at 11 o'clock. So that way y'all can just spend the day with us. Y'all. I think it's the third Tuesday of the month. I'm almost positive. 3rd Tuesday of the month. Okay. So that's that. Who's ready for some legal update? Was there anything else that I needed? Oh, needs and wants? Needs and wants. Nobody needs anything. You still have that that townhome available or whatever it is?
3-story.
Nobody has any needs or wants? No. Okay, fantastic. Legal update time. Are you ready?
I'm ready.
Oh, Shelley has,
Yeah, Morgan's moment.
Wow.
Wants and needs.
Last day.
I don't normally do this, sorry. Here's Shelley for prosperity lending, everybody.
Okay. Wow. Happy Tuesday, everyone. How are you guys doing? Happy holidays? It is Tuesday, right? Wednesday, Tuesday. All right, so I thought I was going to save my thank yous for the end of the, or for the last episode, but of the year, but this is it, huh? This is the
our
last sales
episode
meeting?
of the year.
Last episode of the year. So thank you all for those of you who used Prosperity Lending this year. We had, and thank you all for partnering with us. Know that if you didn't have an opportunity to use us, please get out there and reach out to us. There's myself, Myra, Gabby, Miriam, Tony, Jason, Beverly, all at your disposal. We actually brought in candy canes with the roster attached to it on a QR code, so if you have any questions on that, let me know. I also want to share a new program. I actually talked to Gabby through this. We have a client, her client is actually going to utilize this program. So they are going to be taking advantage of what we call a debt service coverage ratio. Can you guys say that out loud? Debt service coverage ratio, otherwise known as DSCR. Here's the beauty around it. So it is for an investor, but we do not require bank statements, we do not require tax returns, we do not require W-2s. It is a 25 to 30% down payment, 30% at a minimum FICO score of 680, 75% minimum FICO score of 700, and all we're looking at is that the rental amount covers the mortgage payment, so that the debt service is covered at 100%. Does that make sense to everybody? So, what's that? Great question. So the rate is actually 5.25% for a 30-year fixed, 5.5% for a 30-year interest only. How many investors could you pick up how many people do you have that say, hey, I'm a self-employed, but I don't want to show you my tax returns? We typically go down the path of bank statements. That's usually the next option. If that doesn't work, we will go into this program where it would be a debt service coverage ratio. Any questions at all on this? You look stumped, Lizette.
No, I'm just thinking.
Yes.
I'm thinking.
So, I mean, and everybody asks, loan amount is up to $3 million. There's really no other qualification process other than credit score. They do have to show us 1 month bank statement to show that they have the assets. The funds have to be theirs. It can't be gifted or anything like that. Again, minimum FICO score 680, 70%, 700, or 75%, and then the rates in the 5% range. Pretty cool, right? Easy peasy. Awesome. All right, that's all I have. Any questions for me? No?
Where'd you get your sweater?
You know what? I'm actually out of batteries. I have a wardrobe malfunction today, but I got it at the NHL fan shop. Thank you.
.com.
My needs are, I need a 3 double
.com. 3 AAA batteries.
3 AAAs, yes.
I can't believe you didn't show up with bumper batteries. All right, guys, let's do this. It's always a good time when we've got David in the house. We always have some very interesting topics to discuss, to share with you. Where do you want to start?
You tell me. You want to start with recent issues with the division? Do you want to do a review of the year before we dive into that?
Let's do a review of the year.
So I would say the biggest thing that has risen up in the last year has to be the Department of Justice and the National Association of Realtors and the antitrust issue.
Who doesn't know what we're talking about, by the way?
What?
The DOJ. Everybody knows what we're talking about, right?
Tom,
The
put your
DOJ
hand
stuff?
down.
Okay. Tom never knows what we're talking about.
So the Department of Justice has been investigating realtors, the National Association of Realtors, MLSs, for a variety of issues over the last few years. There has also been some lawsuits about commissions that we'll talk about in a minute. But the Department of Justice's issue is a big deal because of just the way that the matter was disclosed. Typically, Department of Justice antitrust investigations are considered confidential. So they do all their investigation up front. The parties participate, and they either reach a resolution by a settlement or they bring a lawsuit. And if you'll remember, at the end of 2019, there was an announcement by the Department of Justice and NAR that they had reached a resolution. of these allegations. There was going to be some changes to MLS rules and regs that we've been talking about, saying these are coming, these are coming, these are coming. And then the Department of Justice earlier this year withdrew from that settlement agreement. The stated reason that they claimed that they withdrew from it was because they wanted to continue to investigate what they felt would be other antitrust-related issues with the National Association of Realtors and the MLSs.
So they said, hey, cool, you're screwing up on this, but we're also going to find all this other crap to come after you all at one time.
Yes, essentially. So NAR said, why are we going to
It's
settle?
like the IRS, yeah.
Why are we
just like
going
the
to
IRS.
settle if you're going to continue to investigate? We don't know exactly what their concern is, but based on their activities, we believe, particularly because of the way that they have made statements about the lawsuits that are out there regarding the amount of commissions that are being paid and the MLS rules, I think that is going to be, to me, that's the biggest thing that happened last year, just because it is extremely rare for the Department of Justice to withdraw from a settlement agreement. That was NAR's entire position. Hey, we negotiated with you in good faith. You told us these were the issues. We resolved them. And now you're saying, no, I want to proceed with your lawsuit. So, again, there's a lot of unknowns. I know for about a year we were saying there's going to be changes to the way, for example, one of the settlement statements is that buyer's agents could no longer tell their clients that their services were free.
Guess what? That changed.
And
Anyway. Sorry, continue.
so my example is that there has been issues out there. So that to me is probably the biggest thing that has happened over the last year. There are several of the lawsuits that are ongoing. COVID has been a difficult time for the courts because generally speaking, you have a constitutional right, if you are a criminal defendant, to have your case go first. I think we had a jury trial in Clark County about 3 months ago, the first time since COVID. So the courts are ridiculously backed up. It's going to take a while for these things to kind of settle out. So hopefully we'll have some more information in the coming year.
Perfect. Any questions on that, the DOJ case? Yes?
So recently in our listing agreement, they've changed that we no longer disclose to the seller how much we're going to be co-oping. And disclosure of commissions is kind of a big deal as part of the DOJ. What is your take on that? Why did they change that? How does that affect us? What should we do about it?
So the question is, in our listing agreement now, we no longer have to disclose how much we are co-oping to the buyer's agent to the seller. And so the reasoning behind that, I guess we're asking you to speculate here. Or do you know? You know the answer? Come on up here. I mean, not that. So why did we do that? What's the purpose, especially since that's a big issue with the DOJ, and that's one of the things that they had some issue with.
So the reason why I went to just the one number was because it is a broker's decision on what we market the property at to sell it, what we want to have that co-op as. We got in trouble because if you remember way back when, it was just the 6% or just 5%, whatever. And then we changed it because people were playing games with it and the co-op wasn't readily available for people to know what it would be. So we added the co-op and gave the seller the opportunity to partake in that decision. Well, with that decision comes the issue with the DOJ, opening up saying that it's costing the seller more money and the buyer more money because that co-op is there. It's not realized as a business decision for us to market the property at whatever we're going to offer somebody else to incentivize them with that. So hence, back to that, single number, and then having the websites advertise what that marketing decision co-op would be that the broker is willing to give out. Not the seller, but the broker is willing to give out. So it changes the dynamics.
Thank you, Tom.
You're welcome.
Perfect.
Clear as mud?
Do you want my honest opinion on this?
Yeah.
Sure, go ahead.
Can you tell us where this is?
No, I would like you to lie to us for the first 30 seconds and then tell us the truth.
It's a brilliant idea. I have concerns with this. I understand where it's coming from. My concern is has this document created unintended consequences and potential liability down the road? I think that that not disclosing to the seller, or not at least having additional language in the listing agreement that explains that this is the amount, this is what I'm going, as a part of this is going to be what I'm going to be offering to the other side, as a part of this is going to be what I'm going to be taking. I think that there is a potential issue I understand why they did it. I think there's a potential issue there with the seller down the road saying, how are you acting in my best interest when I'm giving you 18% in this listing agreement? You are keeping 17.5%, and you are marketing my property at 0.5%. How are you acting in my best interest? How is that the way to ensure that my home is sold? But I also live in a world where I worry about things that most of the time they don't come to fruition. But I could see that could be a potential issue with sellers down the road. I also think that there could be a potential issue internally with what those numbers are going to be. Because as Tom has said, the commission amount is a broker decision, meaning that agents would not be, I think that there would need to have to be some additional paper on the back end figuring out what that commission split is going to be. If it's a 5% and we're going to keep 2.5, the numbers are really irrelevant. The question is under NRS 645, I believe a broker has to be the one who makes that decision. The listing agreement, for example, the listing agent is technically not a party to that agreement. It is an agreement between the brokerage and the seller. The agent is listed as an interested party, but they are not considered to be a contractual party because of the way state statute discusses and governs commission. So I think the other thing that would have to be addressed is, I think you need to have an internal policy of how are you going to make that split. I think a broker needs to sign off on it in writing, and I think that anytime that changes, that a broker would need to sign off on that as well. So I think that there might be some unintended consequences for this. I understand that the idea is we're going to be shifting away from saying this is the amount that the seller is offering, but rather this is the amount that you're paying me as a part of my marketing and service to sell your home. This is the total charge. It's going to cover my costs and fees. Just like if you retain me as an attorney, my hourly rate is this, my support staff's rate is this, and if I have to pay filing fees at the courthouse or anything else like that, you're going to reimburse me. I think that I think it's a well-intentioned decision. I just think that I don't know how the logistics of those two things are going to work going forward. Not necessarily concerned with the Department of Justice, but concerned with an aggressive seller who is saying, please explain to me why, when I ask you what's the amount being offered, explain this to me. And I think that needs to be addressed in writing. And I think that there needs to be some discussion as to how you position yourself to explain why you are charging me 22%, keeping 21%, and I know I'm using extreme examples, and only marketing my home for 1%, and you're taking your marketing costs off the front. Explain that to me. I don't think it's illegal or unlawful. I think that when making this change, I don't know if they've kind of figured out, okay, well, because we've made this change, we're going to need to figure out how to explain this. We might need an additional back-end form for each brokerage to allow for the changes, to describe that split. Because what I don't want to see happen, because in Texas, there was an actual case where in the listing agreement in Texas, they said, listing agent gets X amount, we're going to give Y amount to the buyer's agents, buyer's brokers. The Texas agent in question made those changes without getting permission from the seller. And in Texas, that was considered by a jury to be criminal fraud. And so my concern is that I like where they're going. I just think that maybe there needs to be additional education as to why this was made, and education as to not get yourself in trouble, because I don't know how, for example, the real estate division is going to be looking at an agent being able to switch those commission amounts when by state law only a broker can. So I think it's a great step. I think that there needs to be some additional information and discussion. And I don't think that this was some kind of negligence or anything like that. I just think that sometimes when you make changes, for example, when I was at LVR, we made a change to the purchase agreement in 2014 about homeowners insurance policies and that title insurance. And we had back then the Forms Committee was an open committee, anyone could show up. We had a gentleman show up and say, we should make the change away from title insurance and use this specific phrase. Everyone in the room thought that was a great idea. He seemed to know what he was doing. We made the change. Well, it turned out it was actually a proprietary term for his company, not the other title insurance company, so it created massive amounts of problems that we had to go back, change that, and make that change. And so ever since then, and being really embarrassed and having to go in front of the board of directors and say, I didn't do my job. I didn't do enough due diligence to make sure that this was the right decision to make. So we're going to have to fix it. We're going to have to explain it. We're going to have to go to the cost of changing the forms. So after that experience, when I was there, before we made form changes, I would reach out to the division. I would call my attorneys from other real estate associations in the western states to ask them their ideas, just to make sure that when we weren't rushing out a change, that we weren't creating problems. And so, again, I think that it's a great idea. I understand why they're doing it. I just think that there could be additional potential liability without explaining to a seller what that number is, how we're going to make that split in the best interests of the seller. I understand it is a broker's decision of what they charge, but at the end of the day, the seller is the customer and may want to know how that split is done.
I didn't know if you were going to freeze.
Did I just?
I'm kind of waiting a little bit. So I was going to say, when it comes to if an agent offering a 0.5%, let's say, to the other side, right? I mean, those agents, whether we had the language in there or not, and had that extra, they're going to do it anyway, right? And we're not encouraging that here. I think that even with the change order, like there is an MLS change order that if you put in a specific number in the MLS, you still have to get that signed by the broker to change the commission. Even though it's not addressed in the listing agreement about how much commission is going to the buyer side, the co-op, you still have to make the change with an MLS change order form. That's not just automatic.
So did they change the MLS change order to remove the seller's signature approving that as well? Based on the new changes to the listing agreement?
No, the seller still has to sign it. The broker has to sign it, the agent has to sign it, the seller still has to sign it.
So there to me is an issue. The listing agreement now says, I would say so.
Hiding it. Everybody knows. It's full disclosure.
Because let's just say, I mean, go ahead. I mean, I'm open to discuss this with you and disagree.
and honestly, these are the types of questions that we have. We talk about these things because, is this an issue? Is it going to be an issue? I've seen very, very aggressive sellers bring actions before the division, before the board of directors with ethics cases and lawsuits on these types of things. And so the question is, one paper we're saying the seller has no control, does not need to authorize any change. And then in another document, we're
specific
saying
to the
seller,
co-op is what you're talking about.
The seller
right?
has to authorize a change on the change order form in the MLS to change the amount. I'm not saying what is right or what is wrong. What I am saying is a good lawyer can say, your forms create an inconsistency.
Oh.
So we're going to sue you. And that to me would be an area of concern. That's something that could be easily fixed. The MLS Board of Directors could change the change order. I'll be honest with you, I've never been a big fan of having the change order being the document to change the listing agreement. I always wanted those two separate. The lawyer in me liked that better, but that's traditionally the way it has been. Changing a status in the MLS arguably shouldn't need a seller's permission. That's part of the original listing agreement, but it was decided a long time ago that the change order form would not only change status in the MLS, but would be the one and only vehicle to change or amend the listing agreement.
Yeah.
So,
I get it. Trust me, I understand. Listen, if you guys have questions, by the way, as we're talking, just raise your hand. We'll address that with you. I think we've beat that dead horse. Yes?
yes.
It's dead. I think we're done with that. Yeah, exactly. All right, next topic.
Okay. I think why don't we? You want to jump into?
No. I want to talk about repairs.
Let's
I
talk
was
about
gonna give him an opportunity. We like set this up this morning and then, all right.
Yes, we did.
So let's talk about repairs. Recent issue that just occurred, we had a seller that had a request for repairs that came through. Buyer made some requests for, let's just say roof repairs. Not let's just say, it was roof repairs. And the seller's listing agent gave the seller, a handyman to make the roof repairs, okay? Now there is actual law in reference to handyman, right? And how much work they can do outside of specialized contract work.
Yeah, handymans have essentially a general license, but anything specific. The contractors board makes the real estate division look downright friendly in their investigations. They're extremely aggressive, not only for the handyman, but the people involved,
So I think it needs to be very clear, right? When you refer vendors to your clients, one, they should be, bless you, they should be licensed, right? They should probably have some form of insurance, right? And you need, if you're referring them, you need to make sure, and we talked about this earlier too, is that our agreements give us a little bit of leeway so that we're not in total liability, but they don't protect us 100% if we've downright been, nope, this is who you should use for this repair.
So there's multiple places in the listing agreement and the purchase agreement that is designed to protect you in this scenario. There is language in the RPA that Nevada licensed contractors should be used. I remember 4 months of my life listening to people fight over what the phrase common household maintenance, I think is the phrase they use it. The homeowner can do certain repairs themselves, and fighting over what that phrase means and who makes that decision. For your sake, always recommending Nevada licensed contractors. I would get in the practice of recommending more than one. So if there are issues, I can't turn around and say, well, Vondina recommended the unlicensed handyman,
Right.
who came out and replaced the foundation, and now I'm being sued, and I'm the innocent victim here. I hired this real estate agent to sell my home at a percentage that is no longer disclosed in the listing agreement, and so I'm bringing a lawsuit because I am the innocent victim here. And so in this scenario, it's very important to first of all, make sure that when you're making recommendations saying, here are 3, here are 4, here are 5, any one of them are good. In the listing agreement and the buyer brokerage agreement, there is a section called recommendations where it actually says, hey, Mr. Sanders, all of the recommendations of title companies, of repair people, anything along those lines, they're just my recommendations to you. You're contractually stating that you're going to go out and do your own investigation. You're not going to rely on me. But if you send one email and say, use this guy, he's the best, P.S., he only takes non-sequential bills in an envelope, might be problematic for us when you get sued. So, use a Nevada licensed contractor. The Contractors Board's website has a search engine that says, you can put in the name of the person and see if they've got a license, see if they've been sanctioned, all of that fun stuff. That is available out there. And make sure that you put this in writing. I had a case where I represented a real estate agent who was representing a buyer. They made recommendations in the inspection. They may or may not have had mold. They didn't use the mold form. Turns out there was mold, and so of course the buyer sued everybody. Sued the sellers for not disclosing the mold-like substance, sued the inspectors, sued both agents, buyer and seller, for failing to disclose this. And we spent about 2 days in a mediation trying to resolve this. And one of the issues that came up was the agent in question for the buyer had sent the buyers hundreds of emails over the 4 or 5 months they've been working together. Never once put in writing. If you're concerned that there is mold out there, the inspection says that, maybe you should go out and get a mold inspection, have that taken care of. And the plaintiff's argument was, you put everything else in writing. you didn't put this in writing. And it made it very difficult for us to resolve that case because the agent in question had been practicing for over 20 years. The reason that she stopped putting things in writing is that the clients just stopped responding to her emails, which again reminds me to remind you, the reason why you write an email to your client is not for your client's benefit, it is to protect you down the road from a lawsuit. So even if you make the phone call and say, hey, get a mold inspection, which is what she claimed she did, and I have no reason to doubt her. The buyers, of course, said, she never told us that. We're the innocent, poor victims that are being taken advantage by the greedy real estate people, and we're the victims here. And that's a difficult case to take to a trial, because you're going to be trying to convince a jury that you're the one that is being honest and not the poor buyer victim. So make sure, particularly when you do repairs, that you're saying use Nevada licensed contractors. If you're going to give names, give more than one, and make sure that you're putting that in writing, and make sure that you're saying, okay, we understand, Mr. Sanders, that I told you that you needed to get a mold inspection, and you are not going to do that, because that would have been the difference between tens of thousands of dollars going out the door versus, the case being dismissed.
Which is unfortunate. So if you have, ultimately, if you have any repairs that are going out, send an email, or vendors that you're recommending, send an email. I know we have an entire list that we go through on Agents of Signature. The search bar is the best way to find our vendors. Even if you're doing it that way, you should be contacting these vendors and making sure that they're licensed and insured and all of those things, right? And if you're not, then make sure you have something in your emails that says, hey, Mr. Sanders, I'm going to recommend this person because somebody in the company has been using them, but I want you to do your own research. Make sure that they're licensed, blah, 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 whatever the situation is. Just CYA,
Yeah.
right? Every chance you can. So, yes?
What did you just say with the search bar where for a list? I went on Facebook and.
So on Facebook, Agents of Signature.
I did that, okay. I
On
went
Agents of
Facebook.
Signature, if you use the search bar and you say, for instance, pool repair,
Uh-huh.
you will see all the conversations that
I
have
did
had
that,
any
but
pool
there's
repair
no
issues.
regular list, I gotta go on.
There is
Facebook.
no regular list. Now,
Okay.
I'll give you a secret. My website has a concierge list of vendors that I use.
Thank you.
And that's at realtorvandana.com. If you go under our partners, there's an entire list there. Those are people that I look at, that I literally get their licenses. What happened?
It's not a secret anymore.
It's not a secret anymore. But I look at their licensing information. I make sure that they're insured. So all of that's available. If you want, you can just pull it from there.
Thank you.
And that's the list that I use. Now, I change it once a year to make sure, like if I have a client that says, hey, we hated this guy because he did da-da-da-da-da, then I'm just, then I just find another one, right? Until someone complains about them, unless they're complainers and I don't really care what they say. So, and then there's also a disclaimer on that page. That disclaimer at the very bottom of that page says, listen, I recommended a couple of people, go do your own homework, right? Things might have changed. They might not be licensed anymore. You might not like them. Like, these are just people that I've used in the past. Doesn't mean that you have to.
Thank you.
I would
Yeah.
definitely make sure that you're using a disclaimer in any situation where we're doing that, because while I think it's great that people go on social media and say, hey, does anybody know a good roofer? In a lawsuit.
There's no good roofers in town, let me be clear here.
Well, when I'm taking your deposition and
Right.
I'm going to eviscerate you, let me get this straight. You are a licensed real estate professional. You went on Facebook and asked a bunch of random people who a good roofer is, and that's the name you gave to my client who's created all this damage. How is that complying with your obligations under NRS 645? How is that? Don't you think that would be relevant for them to know? Hey, I don't know any really good roofers, so I asked a bunch of colleagues, and these are the names. I don't know anything about them. Do your own research. Best of luck. Because you are held to a higher standard, unfortunately, and that is a way that people can say, I was taken advantage of. I went to my real estate agent to ask who should be a good roofer. I don't know. And then my real estate agent just went on Facebook and found 3 random people said, use Joe's Roofing, and that's it. So make sure that you have that disclaimer when you are making recommendations for any type of service, just so that it doesn't come back to bite you.
Cool. All right, next topic. Anybody, any more questions? Cool. Did you have a question? No, I thought you did. All right, so we haven't talked about this one, but I thought it'd be really fun to have a discussion about it. So, best practices when you are representing a couple that's divorcing.
Don't do it.
Stop right now. Stop right now. So that is, you can, right?
You can.
And you should.
You should.
Because somebody's going to do it. It might as well be you.
Okay. So let me ask a couple quick follow-up questions, and these are the questions that you should be asking when you have a couple that says we are getting divorced. Okay, well, where exactly are you in your divorce process? If they've already got a divorce decree and the court says
Sell the house.
There's going to be language in that court order explaining who gets to be the agent who does that.
Or who gets to decide who's going to be the agent that does that.
And that will save you
Or
money.
how they're going to decide. Because
Exactly.
it could be he picks one, she picks one, or she picks one and she picks one, or he picks one and he picks, you get what I'm saying. But it could be that one of them gets to pick one, the other one gets to pick one, and then they get to decide together.
Yeah,
Right? Or whatever.
I actually had a scenario where I had to tell the agent, look, the divorce decree specifically said that your client, ex-husband, got to pick agent for 18 to 24 months to sell the house. If the house wasn't sold within that period, then ex-wife gets to choose. And the home wasn't sold. And, that's a difficult spot. So if you were going to be working with someone in that scenario, the first thing you need to say is, do you have a divorce attorney? You need to ask for your divorce decree. You need to ask your divorce attorney where we're at. Because if they haven't got the final decree and they're negotiating, they could put language in the divorce decree to allow you to sell the home. But those are always kind of sketchy. The judge in the family court, they get to make, that order is controlling, period. And so whatever that is the first thing that you need to say. If they haven't got to that part, then I think getting the contact information from the divorce attorney to make the phone call. Hey, they're contacting me, they want me to list the house. I just thought it'd be a good idea for me to call and introduce myself. Is there anything in the case that I need to know about? Is there anything that's going to impact that? Who makes those decisions? Who's going to decide if they're going to pay for repairs? Is that going to be split 50-50? Who's going to be doing that? Who makes those decisions? Because technically, until the divorce decree comes through, they are, assuming it's a community property, and that both husband and wife or the spouses are both on title, all of those fun things. It can get very, very confusing. And what would really be unfortunate is if you listed a home, you did all that work, and then the other spouse's attorney sends off a nastygram, which we get all the time, saying you need to cease and desist, here's the court order, and you're just out of luck. And the answer is, I'm sorry, you're out of luck. It's not like you can go down to the family court judge and say, but Your Honor,
I did all this work.
I did all this work. I should be, paid my 18.5% commission in the listing agreement, or whatever that is.
So when we say 18.5, we can say that out loud in public? Is
It's
that
an
allowed?
example.
That's not an antitrust violation?
Look, if I could convince someone that the Dave Sanders real estate experience is worth 150% commission of the purchase price, I don't think it's illegal. See me afterwards if you're interested in that, because I will also sell you a bridge. But it's not necessarily unlawful. The antitrust issues are if...
I don't want to get into that. Let's go back. We can talk about something else. Let's go back to this divorce thing really quick. Antitrust is going to be a more complicated... we've had this conversation before. But I want to go back to the divorce couple, or the divorcing couple. So I always recommend that whatever you say to one, you must say to the other, right? Otherwise, you could be in some serious problem, especially if they're not communicating and in the same room. And to do that the best, so let's say you talk to the one partner and you say, hey, so we're going to talk about A, B, and C. And they're like, cool, you have that discussion, you write down the notes and the conversation, You go to the next person and you say, here's A, B, and C, and they're like, well, what about da-da-da? Great, you write that down, you go back to the first one, you talk about D, right? So you've got ABC, ABCD, you go back, talk about D. You have to do that.
Yes, and you also need to be very mindful if they are both represented by attorneys separately. You know,
Those guys.
I was just thinking, what a lovely, polite divorce you're talking about, where they're both in the same room, they've agreed upon a real estate
I've had that
agent,
happen several
and they're
times,
willing to
yeah.
actually sell the house together.
They love me so
You know,
much, they don't care.
That's one thing, but you need to make sure that there's that the attorneys, because the attorneys may want to be involved in this process, not necessarily like, you know, you need to run everything by me. It's like, hey, you should probably include my lawyer on this. The lawyers may want to say, hey, we want you to do separate communication. We want to talk to you that way. And that's not in the sense that the divorce attorneys are trying to make your job more difficult. They're actually trying to make it easier for you to sell the house, because we all have had scenarios where clients are not exactly forthcoming on what is actually happening. You know, I'm sure you've had the client who says, nope, there's nothing in my divorce decree that says that you know, my ex-spouse gets to make a decision about the sale of the home, and then you actually get a copy of it, and it says something completely different. So those are the major, I would say, pitfalls that you would run into with divorcing people. And if they're representing themselves, you know, that can also be issues as well. So I would certainly want to lead off with, do you have an attorney? Have you filed a case? What's the status? And those would be the questions I would start with.
And then also, I lost my train of thought. God dang it, David. I had something that was kind of important and I forgot. I'll come back to it. All right, so divorces. Fun? Let's do,
I enjoyed mine.
all right, let's go. Me too. All right, so let's go into some of the allegations and stuff that have come about and the violations that have occurred at the real estate division. You love going to those things. I love going to those things as long as we're not invited, right, Janet? None of us ever want to be invited.
They're actually, they started this
They're a
morning.
lot of fun. Oh, they did?
Yeah.
Okay.
It's today, tomorrow, and Thursday.
So you get credit, you get CE credit for attending these things. 3 hours a day.
I would say with the caveat, I don't know exactly what they're doing with COVID. They used to.
That's still a thing?
Apparently.
Okay.
They used to have the hearings by Zoom call. The September hearings, they required the parties and their attorneys to be present, and then everything else was a phone call. So if you can imagine 9 hours of telephone call, no video, that's how they were doing it in September. I'm not exactly sure what they're doing with offering credit for people who make the phone call in. I know historically they have offered it. I just would hate for people to get on the call tomorrow and not being offered just because of COVID restrictions and the way they're handling these things. But you know, historically speaking, anyone could show up and attend and watch and get credit.
They're a lot of fun to watch and listen to. So let's talk about a case in regards to, I think the one thing that gets beat to death in the commission hearings is property management, right? Licensees acting as property managers when they don't have a permit. You also have now as business brokers, you cannot act as a business broker without a permit, right? There's a couple of permits that you have to receive in addition to your license. So let's talk a little bit about that, because there's several cases from the last hearing that address property management.
The first thing I would tell you to take away is under no circumstances ever should you handle, touch, or be involved with any client's funds if they are a tenant and they're going to be involved in renting a property. There was a discussion with the commissioners in the September hearing. If the act of a non-property property management licensee delivering a check from tenant to landlord was acting as a property manager without a license.
So that blows my mind, because that was a security deposit. That wasn't an actual rent check, right? I mean,
Yes.
unless you're a property manager here, we do not take rent checks, right? Period, the end. You cannot have them brought to our office. They cannot be written out to our company. Unless you are a property manager and you're managing the property, you're not allowed to do that. Everybody knows that, right? So it can't be written out to the landlord and have it delivered here. I don't care where the landlord lives. It's not allowed, okay?
Yeah. So I would be very, if your business model is you are helping tenants to be placed in rental properties. I wouldn't want to touch any of the funds, say, I can't do it, it's illegal, unlawful. State law does not allow me to, pick up a check for you and take it over to the landlord. I can't do that. Now, the commission's changing, there's new members coming on, there are existing members who are cycling off. So sometimes whether or not they're going to determine that is property management is unknown. They've kind of gone back and forth on that. But again, their big thing is always, staying with you in your lane. So if you have questions and you do a lot of tenant placement and you do not have a property management license, it is in your best interest to go speak to your broker and make sure that you understand how far you can go and not get into trouble. I don't know it's not like, I don't think any of these people actually, intentionally withheld funds, but there's multiple repeat offenders in these situations where they have routinely not been able to be clear on what their role is as a property manager versus a non-licensee. There are certain things you can do as a real estate licensee. You can certainly help them, write. There's certain things that you can do. There are certain things you cannot do. And the people who get in trouble historically are the ones who continue to make the same mistakes. So it's not, if you look through the division's open house, the people that are getting the massive fines have been doing this before, second or third chance offense, and it's not exactly easy to argue that they have learned their lesson and should not be sanctioned.
After the third time, do they go to real estate jail? Like that's the thing.
Well,
Third offense.
What I can tell you is in the scenarios that I have represented clients before the commissioners, I'm just going to say, look, you've got 5 people. You have to convince 3 of them to not take your license away. And these 2 are going to want to take your license away. And
I should never be a commissioner. I will take everybody's license. All this stuff right here, I would take everybody's license
It's
away.
on video, so you'll never be.
Oh my God.
It's a different analysis, and I would say that if you in the situation, if you ever do get hit by the division, after working with them over the years, it is in my opinion that it is the best thing to do to cooperate with them as quickly as possible. Typically speaking, if you're going to get an offer, your best one's going to be the first one. Vonda and I just talked about this. The division about a year and a half ago started charging you the costs for the investigation. So you're not just getting a $2,000 fine. You're getting, for example, I remember a gentleman came all the way in from Pahrump, refused the settlement for $500 because he wanted to make his argument in front of the commissioners about that. In his listing agreement, he said that he would put the property in the MLS. He's a non-realtor, meaning that he does not have access to the MLS. Put it on.
Oh, I remember that one.
Put on other websites, different places, and the commissioners looked at him and said, you literally could have just added a sentence in the additional terms. Parties acknowledge, we're not going to put it in the MLS, but we'll put it on places like Zillow or Realtor.com, et cetera, et cetera. He came down, drove all the way in from Pahrump, made his argument for 5 minutes. The panel said, okay, thanks, you're in violation. Here's your $500 fine, and the cost of the investigation is $2,583. So his decision to get up and say, let me tell you why Zillow and the MLS are the same thing, cost him a lot of money. And those investigation costs only increase. And the big numbers come last week when the AGs are all prepping for the cases this week. So if you get in that scenario, it is in your best interest to go speak to your broker as quickly as possible and figure out a way to resolve it. It doesn't mean you're a bad person. It doesn't mean you are a terrible real estate professional. These things happen, but it's very important to take it seriously.
I remember what I had to say about the divorce thing. I'm going to go back for a hot second. If there are attorneys involved on both sides, by the way, make sure your broker's involved. Like, come and talk to us. Let us help you write those emails. Let us help you, figure that out, because then it's also our doing. We'll probably call him anyway.
Yeah, it's going to be a hot mess if both the attorneys are there and they have not agreed in the divorce. The ideal situation for you with the divorce is they will either agree to hire you or they have a divorce decree that says this is what you have to do. Then at least you know where you stand. Where it's going to get problematic is where it's adversarial and one lawyer is saying, I want to use this signature agent, and the other attorney is saying, well, my cousin just became a real estate agent, and I want to use somebody else. And then they will go down and fight down at the courthouse. So, it's certainly in your best interest to go speak to your broker, because it might be a situation where you tell them, gosh, I'd love to list your house, but considering how contentious this is, you either need to agree, and I'll list it when the judge says it's okay, or you get a writing agreement in writing with the other sides that they agree to it, so that you don't go to all that effort.
Cool. Fast forward now back to property management really quickly. On that, when it comes to property management or trying to do property management type activities, you are only allowed to list the property in the MLS, and you are only allowed to write the lease agreement for your client. If the landlord intends to manage it, we have some language, by the way. You could reach out if you're going to write a lease agreement. We have language that you can use that will protect you and us. So ask your broker for it. But you can also, so you write the lease agreement. If it's going to be landlord managed, you have to use the one that's AB 161, which David begrudgingly agreed to put together for very, very begrudging. I can't even say the word anymore. I said it the one time, that's all you get. Yeah, so I think that's important distinction to make there, because you can do those things, but nothing money related, right? You don't want to mess with that. It's not worth
even
it.
so,
Nothing vendor related. You can't get vendors over there to do some work for the tenants. If the landlord's out of town, they call you and they're like, hey, I need so and so. You can't arrange that. They've got to figure it out.
That was actually one of the defenses to one of the people at the September hearings were, hey, the landlord is my friend. They asked me to help coordinate some of the repairs and the contractors, and I wasn't doing it as a real estate licensee. We're buddies, and he was out of town, and so I helped, and the commissioners didn't really like that argument.
Because you're not just a friend, you're a licensee, and you're held at a higher standard, and you have to disclose that. Sorry, did you finish your thought? Okay. So, and the other thing with property management is if you are a landlord, by the way, if you are on title, and I talk about this in my classes, you can actually manage your own properties. You have to disclose that you're a licensee, right? And you can manage your own properties. They can't come through here, but you can do it on your own. And it is, there used to be, I don't know where it came from, there used to be a time where you said, hey, you can only manage up to 3. Somebody said it, and then it just sort of like fire. Everybody thought that you could do a total of 3. You can do as many as you want, as long as you're on title, right? That doesn't mean that you're in an LLC and it's owned by someone, like you all have, sorry, you had a question.
I thought it was 5, but.
No, there's no actual limit. I've looked at the actual law on it, and there is no limit to that. If you are a owner of the property, you are on title.
Yeah. You would just,
right?
Yeah. You have
the attorney here before I talk about law.
You have the right as a property owner to self-manage.
Yeah.
As long as you're complying with the local requirements for the property, you have the right to do that. Where it gets sticky. I was gonna go with fuzzy, but sticky works.
Janky.
Wonky. Is when.
Sorry, go ahead.
is when those start to overlap. For example, you were disclosing that you're a real estate licensee, but the contact address for your lease agreement should not be your business address.
Correct.
Because then it creates that appearance that you are doing it as a professional licensee versus an individual homeowner.
Okay, that brings us up a really good point, by the way. So you're going to manage the property by yourself, right? Because you are the landlord, you're on title. Can you use the form in LVR to do it? Aha!
Technically, no.
Wait, what? Why?
No one likes this answer. Technically, the limited license.
I mean, it's better than it depends, but yes.
Technically, you're licensed to. You have a license to use the forms from LVR in your role as a professional real estate licensee. Admittedly, they may have changed this in the last few years, but when I was there, it was always one of those scenarios that technically it's for you as a licensed real estate professional. It's not to be used for your personal use. Whether or not they're going to send the LVR cops down and kick down the door and take the forms away, I don't know. They were more concerned about non-realtors stealing the forms and using them, in a non-realtor brokerage, which happened a lot. If you run into a situation where you have a non-realtor who is using realtor forms, you don't have to burn your transaction down. That's something that you can wait till the transaction is done and report it to LVR, because they're the only ones who can enforce it, because they own the copyrights and the trademarks.
Okay, I'm gonna respectfully disagree with you,
Okay.
and here's why. And we can talk about this, right?
Okay.
Because I think that's what this is for. And I kind of want you guys to chime in and tell me if I'm right. I'm right. So you are a licensee, right? You're a realtor. You have access to the MLS. You can go get those forms, the AB 161 lease agreement, for a client that's not you, but you can't do it for a client that is you? As long as you have the proper disclosure and disclaimer, right? Do you hear what I'm saying?
You're not a client, though. You're
I
servicing yourself.
I understand, but it's through, oh, so you agree with him? You agree with
Are
him?
you gonna pay yourself? Because a client, and we have to.
I mean, I will pay the other side. So I own a house, I'm a licensee,
So
I'm a
here-
realtor.
And here's the best part. It doesn't
Wait, but I'm
matter
not-
what I think. It doesn't matter what she thinks.
It matters.
It matters what LVR says, because they own the forms. So if when I was there, it was always one of those touchy things that technically the license agreement is for your professional real estate business, and you're now telling me that I'm owning these properties in my individual capacity. I am not acting as a licensee under a 645, except when I want.
But I could list the property in the MLS, right?
Except when I want these special forms that no one else can get.
Okay,
Then I'm
but,
going to go take those, and that's okay.
but I could list them in the MLS, the properties in the MLS that I own?
Can I?
I'm
If
asking you.
Now, if I'm acting, well, okay, where's your listing agreement? Where's your listing agreement?
With myself, which
With
you can't
yourself.
do. Okay. I'm talking this through. Do you see how this
This
is
is all,
happening? Okay.
again, this is all
So-
hypothetical. I could be absolutely wrong. This is LVR's, could be. This is LVR's decision to enforce and control. I can tell you that the way the license agreements were written, when your brokerages sign up and agree to use the forms, that they're for professional purposes only. This is one of those areas that is a bit sticky. It doesn't matter what my opinion is. It's also one of those things that I don't know if you want to go storming down to LVR and say, we want you to definitively answer this question. Because they may come back and say, no, you can't. Or yes, you can.
So, but the way to resolve that is that you just get your property manager's permit and then you're able to.
No, you get someone in the office to list the property for you and provide you with a lease agreement. I mean, let's be real here. Go ahead.
So I'm gonna err on Bono's side, because I don't really see the difference here. I pay my dues to LVR. I pay my fees to MLS. Now,
Janet said I was right, by the way, just for you at home. Go ahead.
I own a house, I want to sell my house.
Rent.
I can use the LVR listing form. I can give myself the duties owed. I can put it on the MLS, but there's nobody getting paid. I'm not paying me.
So for me, the difference comes down to property management. I agree with you in that scenario. But in property management, what we're saying is, I am a Nevada licensed
And
real
you're not
estate.
a
I am not I am Nevada licensed real estate licensee. I am not a permitted property manager. I do not need a property management license because I am managing homes that I own in my individual non-business capacity. So it's almost a loophole, right? I can manage these. I don't have to be a property manager.
But you still have to disclose that you're a licensee.
You still have to disclose you're a
even if you
licensee.
use forms that are
And
outside of the
so
LVR.
the question then becomes, are you acting in your individual, and this is a legal thing that lawyers will argue over, and it probably doesn't have any impact on your day-to-day, but this is where I'm coming from. If I'm standing up in front of the division and saying, I don't have to be a property manager because I'm acting in my individual capacity that is not a real estate professional, then how can I then say, I'm going to get these forms as a real estate professional?
All right, well, I mean, I think that's definitely worth us looking into a little bit further and coming back for
There wasn't,
discussion.
when I was...
Sorry, Chris,
when
I
was-
screwed this up.
When I was in-house for the realtors, it was one of those things that I never came up with a good answer, because if they came out and say, then you are exempted, then we've got to change licensing agreements with like Transaction Desk, and all those people who have requirements. You have to be a professional, you have to be the member. it's not as, the legal aspects are more messy than I think you even knew when we started talking about this.
Yeah, I mean, I can see how it would be messy, whatever. All right, any questions, you guys? Yes,
So in a scenario, this is kind of on this area, landlord has a month-to-month tenant. The month-to-month tenant puts in a 30-day notice that he's gonna leave in 30 days. Should that landlord still go through the eviction process, or should you just wait and wait till the end? I just need to know this.
It
It's kind of like
depends.
5 answers.
It depends.
Did you say it depends?
It depends.
Yeah.
In what?
so
If I
to
get
err
my-
on the side of caution, I would say, move forward with an eviction or a notice from the landlord saying, here's your 30-day notice. Now the landlord has noticed them about their 30 days. That way, if the tenant doesn't move out, now you have an opportunity to go after them for eviction.
Otherwise, you wait till the 30 days and then you do the 7-day, then the 30-day.
If they don't pay, right?
Right.
But-
Which
so
they're
we're-
not- they're not
If the
paying.
tenant vacates within the 30-day window, then there's no need to evict at all.
Right.
If they say, hey, I'm leaving, I'm giving you my 30 days notice, if they're responsible enough to actually give you the tenant's
They
notice,
did in writing that says that they're
I'm
leaving.
going to be out,
Yeah.
then, that would be a situation if you are concerned that they are not going to vacate, then possibly starting the eviction process, potentially. I think technically the tenant isn't in any kind of violation of the
He's
lease.
not payment, he's not gonna pay.
Well, he's not going to pay for next month. I hate to give the lawyer answer of it depends, but in these types of situations, it's going to be very, very fact-based. Did they leave? What kind of notice did they give? Did they trash the place on the way out? All of those things. There's not a cookie-cutter answer for that scenario. Because if they vacate, there's no reason to file the eviction.
Right.
If
If they don't,
and I can
you're
see-
losing 30 days.
So what I'm gonna say is like when we get 30-day notice from a tenant, right? As a property manager, I respond back and say, here's all the things that are gonna be required for your move out. Please prepare for your 30-day, for your move out within the next 30 days. Now they have our notice, they've given us notice, and it's like everybody knows what the rules of engagement are here, right? Now you're not a property manager, so you can't do that, but the seller can, and say, I'm in receipt of your 30-day notice. Here's the things that I'm gonna ask of you for, before you move out. Make sure the property's clean, make sure that it's in the same condition, blah, 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 all those things,
It's like an acknowledgement of receipt.
Yeah. Yeah,
I would also want to acknowledge that to make sure that you both are clear on those 30-day window. If they mailed it, for example, by US mail, is it the date of the notice? Is it the date it's postmarked? Is it the date you
There's
get
a
it?
date in the paragraph that says he's gonna be leaving at January 13th.
Okay, so again, it all depends on what that notice actually says.
Okay.
If it's an email saying, hey, we're gonna move out at the end of the month, I would definitely agree with Vonda that you want some clarification. You want to make sure it's very clear as to what those regards are. You want to know when they're going to do the walkthrough. Are you going to want to be there? If you're a property manager, all of those things. So,
but this brings up a really good point too. You're not a property manager, you can't get involved in this.
Personal property.
Okay,
It's our own property.
cool. Well, can't use the LVR forms. So with that.
I would ask the owner of the property for a raise.
Right?
No.
All right, guys, with that, we're at time here. If you have any questions, David's going to be around for a little bit longer. We're sorry if we totally confused the heck out of you. Ask us questions at a later time. Thanks so much. Go sell some stuff, and happy flippin' holidays. Bye.